Hello students, my name is Dr. Alice Mani. I will be imparting lessons on Business Law, course 306. I am the resource person for Mahatma Gandhi National Council of Rural Education. I will be imparting lessons on Business Law. This is part of the BBA Rural Management course. This course is divided into 4 units. You will have 16 modules covering the syllabus. The 4 modules will be: the first module is an introductory chapter. Second chapter is various acts. The third is Sale of Goods Act, and the fourth and last chapter is Consumer Protection Act 2019. We will begin the first unit, which is Introduction to Business Law and the Indian Contract Act. This unit will be covered in 3 modules. The first module will look at the introduction to law, business law, and sources of business law. The second module will cover the 10 essential elements of a valid contract. And the third and the last module will cover the types of contracts. This lesson, which is module 2 of chapter 1, will give an introduction to the Indian Contract Act. This module has been structured to cover 3 broad areas in the following way. First, I will introduce the meaning and importance of the Indian Contract Act. Second, we will learn the definition of contract. The objective of the third module is to learn the 10 essential elements of a valid contract. At the end of this lesson, you will be able to understand the need and importance of the Indian Contract Act, get insights into the definition of contract, and also to learn about an important aspect, that is the 10 essential elements of a valid contract. Have you heard about the term contract? What is contract? We come across many contracts in our day-to-day lives. When we travel in an aircraft, bus, taxi, or train, a contract is present for the services we enjoy and the prices paid for the same. Similarly, when we open a bank account or buy shares, insurance products, vehicles, property, consumer durables, etc., there is a contract between the parties. So, we can say that the Indian Contract Act has got a lot of relevance to us as individuals. Now, what is the relevance of contracts in business? The Indian Contract Act validates the contracts and agreements between parties in business. This act regulates the overall business transactions. Thus, Indian Contract Act plays a vital role in business transactions. The business or trade cannot run smoothly without this act. This does not mean that this act affects only business. It affects everyone in one way or the other. The law of contracts existed from the early stages of human civilization. Just like the safety of person and property depend upon the rules of criminal law, the security and stability of business is dependent upon the law of contracts. Enforceability of promises is the base of trade and commerce, and it is impossible to enter into transactions if we do not have the assurance that agreements once made could be binding. This is the basis of law of contracts. The parties entering into contracts have 2 alternatives open to them. They can either rely on the other's owner to ensure performance, or they can make it a legally enforceable agreement. The word owner is not found in business. Therefore, all the agreements are made legally enforceable. Legally enforceable promises are termed as contracts. The object and function of the law of contracts is to see that exceptions created by promises between the parties are fulfilled and the agreements are enforced. Thus, contracts bind our economic system together. Therefore, the sanctity of contract is the objective of social control and individual liberty. In short, a contract is an exchange of promises by two or more persons resulting in an obligation to do and refrain from doing a particular act. In other words, a contract gives a right to one person and casts a corresponding duty on another person. On the basis of these rights and obligations, there is a remedy in the Contract Act if it is not performed. Hence, a contract is sometimes referred to as an agreement creating an obligation. However, all obligations are not contractual in nature. Examples for obligations which are not contractual in nature are agreements which are social in nature. What are social contracts? Have you heard about it? Are you familiar with this term? I hope you know that. If your friend invites you for a dinner and you agreed, there is not a contract signed between you and your friend. Imagine you couldn't honor your word. But the friend cannot take the action against you because this is a social contract. Other examples of social contracts are if you agree with a friend to go for a movie, dinner, shopping, etc. are all social contracts. A social contract is not an actual contract. No one signs a social contract. The Indian Contract Act 1872 also serves as our protection in every legal agreement we make in life. Contract Act makes these agreements enforceable, which we will be entering into in our day-to-day lives. The enforceability of Contract Act means that it gives the other party the power to compensate and obtain damages for breach of contract. The Contract Act also provides remedies for breach of contract. This is the importance of Contract Act for business and in our individual dealings. Imagine yourself as the owner of a startup or business unit or providing services like consultancy, engineering, hospital, etc. Then the relevance of this act is much more. First thing you should remember that a contract is that when a contract is entered into between two parties, it creates an obligation between the parties. The advantage of this is that if a contract is not fulfilled, remedies are available in the Contract Act for breach of contract. This creates a legal bonding between the parties. Let me take a simple example. If you want to buy a flat from a builder, when the agreement is signed as a buyer, it is your duty to make payments on time. Similarly, the builder has to complete the construction as per the agreement. If it is not compiled by any party, legal consequences will be present. Now, what about social obligations? Do you know what a social obligation is? Social obligation for an individual is an informal need to do something based on social obligations. For example, you have agreed to watch a movie with your friends, but due to some unavoidable circumstances, you had to cancel that at the last minute. Please remember that not fulfilling social obligations will not create any legal obligations. To sum up, if a valid contract is entered between the parties, they can enforce obligations agreed upon. Now, let us see the definition of contract. It is an agreement enforceable by law, which is a contract. A contract, therefore, is an agreement, the object of which is to create a legal obligation. That is, a duty enforceable by law. Thus, as per the above definition, A contract essentially consists of two elements. First, it is an agreement, and second, it's a legal obligation that is enforceable by law. For example, if I am entering into an annual maintenance contract for my water purifier, by paying the required amount, I am entitled to get the 4 quarterly maintenance. The service provider has a legal obligation to do the quarterly maintenance. This is an example for a contract. What are the essential elements of a valid contract? As we have already discussed and understood, a contract is an agreement and a legal obligation. There are 10 essential conditions to be fulfilled as per Section 10 of the Indian Contract Act to make it a valid contract. Now we will learn the 10 essential elements of a valid contract. Can you imagine the 10 essential conditions? Can you take 5 minutes of your time and write the 10 conditions to make a valid contract? You have some idea about the essential conditions for a contract from the explanation we have already completed. I know that and assume that you will get some points correct. Now let me tell you the 10 essential conditions. First, it is consensus ad idem. Second, intention to create legal obligation. Third, lawful consideration. Fourth, capacity of parties. Fifth, free consent. Sixth, lawful object. Seventh, writing and registration. Eighth, certainty of meaning. Ninth, possibility of performance. Lastly, 10th, not expressly declared void. Now, can you compare your answers with the points given as essential conditions for a valid contract? The first condition is consensus ad idem. This means that parties should agree on the subject matter in the same sense and time. Let me take an example to further explain this point. If the contract is to buy a vehicle, the model, color, type, terms of payment, etc. should be discussed and finalized by both the parties. Then only it will become a valid contract. The second condition is that parties are willing to create a legal obligation when they enter into a contract. For example, if I am entering into a contract with a publisher to write a book on business law, my intention is to get the book published for a royalty from the publisher. Publisher's intention will be to sell the books and make money out of it. The reason is that the publishing contract, when signed by both the parties, will give rise to a contract. The third essential element is lawful consideration. Do you know the meaning of consideration? Consideration means something in return. When I work for a university as a professor, my consideration is the salary I earn. So for every legal activity, consideration is granted. You have to remember that in a legal contract, both the parties are benefited. For example, if you purchase a notebook, you receive the notebook and the shopkeeper earns money. But it is important to remember that consideration has to be legal. If the consideration agreed upon is sale of illegal substances, murder, threatening someone, etc., they are not considered as legal consideration. Consideration need not be in cash or kind. It can be an abstinence or promise to do or not to do something. The meaning of abstinence is abstaining from something. Examples are in business contracts, when a dealer is getting exclusive distribution rights for a state, he will enter into a contract with the manufacturer or wholesaler that he will not sell the item in other states. An example for consideration in kind is that Your parents promise you that if you get distinction in final examination, they will buy a two-wheeler for you. Consideration can be even past, present or future. But it must be real and lawful. For example, if you see an advertisement announcing that those who find the missing dog will get a reward of 10,000 rupees. This is an example for future consideration. Fourth essential condition is the capacity of the parties to enter into a contract. We all know that a contract is entered into by a minor is not valid. Similarly, a person undergoing psychiatric treatment, drug addicts, alcoholics, etc. are not eligible to enter into contracts. It is very important that parties should be legally eligible to enter into a contract to make it valid. For example, a girl under the age of 18 enters into a contract with the builder to buy a flat. It's not a valid contract. As per Section 11 of the Indian Contract Act, in order to be competent to contract, the parties must be of the age of majority, sound mind, and must not be disqualified from contracting by any law. For example, a bankrupt is disqualified from entering into contracts. The next essential element is the voluntary consent to enter into the contract between the parties. If the consent is obtained by fraud, misrepresentation, or any other unfair means, it would not have any legal validity. For example, a stolen laptop sold by claiming to be the rightful owner has no legal validity. The reason is that the contract is entered between the parties by misrepresentation. Then the contract is not valid. The next essential element is the involvement of a lawful object. The object is unlawful if it is forbidden by any act of our country. For example, if a landlord knowingly rents his house to a terrorist, the object is unlawful because the object of the contract is unlawful. The contracts are valid only if it is written and registered. The word of honor is not always the norm in actual practice. Therefore, we give legal validity to contracts by writing and registering. To make it a valid contract, contracts must be written, signed by the both parties and registered. In India, written and registered contracts are a must in cases like gift, lease, mortgage, sale of immovable property, acknowledgement of debt, family partition, etc. The next condition is certainty of meaning. If we write an agreement as an educational institution with the supplier of books, it is not a valid contract. Can you tell me the reason for that? It will become a valid contract only when the agreement is to supply a specific subject and the author. The next condition is that possibility of performance. The contract, when entered into, should be capable of performing. For example, if a person enters into a contract to take you to the moon, it is not a valid contract as it is not humanly possible. As per Section 56 of the Indian Contract Act, an agreement to do an impossible act in itself is void. Can you think of other examples which are humanly impossible to perform? This is a simple task. You can think of inventing treasure by magic, promise to take you to the sun, etc. All these contracts are void due to impossibility of performance. The 10th and last essential condition is that a contract should not be expressly declared void. An agreement in restraint of trade or marriage are void contracts. Everybody has the right to carry on the business of their choice and the right to marry the person of choice if they are majors. For example, if the girl is 18 years and the boy is 21 years, they have the right to marry. Nobody has the right to stop them, even if it's their parents. Our learning wouldn't be complete if we don't assess what we have learned. So, here is an activity for you. Write a contract which fulfills all the essential conditions of a valid contract. That we have reached the end of this lesson. In this module, we have covered 10 essential elements of a valid contract. So, this is from the chapter 1 of business law. Chapter 1 heading is Introduction to Business Law and Indian Contract Act. As already mentioned, this chapter is covered in 3 modules. The first module we covered as the video lesson 1, that is, what is law, what is business law, what are the sources of business law. This was the second module, that is, the Indian Contract Act, the basic features and 10 essential elements for a valid contract. And the fourth topic will be the types of contracts. That 4 broad categories are there and with its subdivisions. This I will be covering as a next module in the next video lesson. Hope you got a good insight on the topics we discussed in this module. Thank you.